speakers. We have with us Deputy Speaker Raymond Democrito Mendoza of Party List TDCP, Honorable Vice Chairperson Keith Micah, Attorney Mike Tan of Honorable Marco of the Law District of Baguio City. Likewise, we are pleased to acknowledge and welcome the presence of our resource persons from the government agencies, starting off with the Department of Labor and Employment. We have Attorney Ramon Saura III of the Bureau of Labor Relations, Director Ama Karisma Sutumba of the Bureau of Workers and Special Concerns, Mr. Joel Trillafuerte and Ms. Shara Luis Calbuza of the Bureau of Local Employment. From the department's attached agency, we have Deputy Executive Director Teresita Audia of the National Conciliation Mediation Board, and Attorney Kim Marie Roque Aquino also of NCMB. Ms. Katie Rafael, the Department's Legislative Liaison Specialist, is also with us today. From other government agencies, we have a representative from the Union of Local Authorities of the Philippines, Mr. Cyprus James Magsino, Mr. Edwin Bustillos and Ms. Naira Ramos of the National Anti-Poverty Commission, Ms. Nihal Pacalna and Mr. Gibro Copino of the Department of Budget and Management. Representing the labor groups are the following: Mr. Louis Coral of the Trade Union Congress of the Philippines, Mr. Lito Ozares of KMU of Kilosamayo Uno or KMU, Ms. Imelda de la Cruz, and Mr. Roel Sabado of the Philippine Government Employees Association. Also in attendance is the representative of the management or employer sector, Mr. Virginia Ayala of the Bankers Association of the Philippines. That will be all, Your Honor. Thank you po. Ma'am Arlene Rosas of Gabriela, Party List Gabriela. Yahoo.
Thank you. Thank you, Committee Secretary. Our first item on the agenda is discussion on House Bill 7043, strengthening the right to strike. We would like to acknowledge our Deputy Speaker, Raymond Mendoza, for his sponsorship speech.
Well, with the sponsorship speech, Mr. Chair, will be attached to that for the record. Can we go straight to what we intend to amend under 263, Mr. Chair? If possible.
Yes, Deputy Speaker. The manifestation is hereby approved.
Under Section 3, Mr. Chair, this is letter G, and in line with the national concern for this purpose, the contending parties are strictly enjoined to comply with such orders, prohibitions, injunctions as are issued by Secretary of Labor and Employment or the Commission under pain of immediate disciplinary action. Exempt dismissal, Mr. Chair, I'd like to introduce exempt dismissal or loss of employment status, including, that's it, Mr. Chair, for Section 3. Mr. Chair.
Thank you, Deputy Speaker. Can we hear first from our representatives from the Department of Labor regarding the proposed amendment on Section 3? Attorney Ramon Saura, Bureau of Labor Relations.
Good morning, Mr. Chair. Apologies, I don't have the one that we reviewed will be the amendments on 263, 264A, and 272.
Section 3 refers to removing dismissal or loss of employment status. Can we hear the Department of Labor's stand on the proposed amendments?
Your Honor, if we refer to the knowingly participation in the illegal strike and knowingly participation in committing the illegal acts, Your Honor. At the moment, we have only some initial thoughts on this. The Bureau has not made a definite position. But if in that connection, Your Honor, we our initial thoughts on this would be that in knowingly participating in illegal strike, union officers have the duty, if I may, the rationale why there is an automatic considering the dismissal of the one who knowingly participates in an illegal strike for union officers would be that union officers have the duty to guide their members to respect the law. If instead of doing so, the officers urge the members to violate the law and defy the duly constituted authorities, the dismissal from the service is a just penalty or sanction for their unlawful act as held by the Supreme Court. As officers of the union, they are tasked with a duty to lead and guide the membership in decision-making on union activities in accordance with law, government rules and regulations, and established labor practices. The leaders are expected to recommend actions that are arrived at with circumspection and contemplation, and always to keep paramount the best interests of the members and the union within the bounds of law. If the implementation of an illegal strike is the one he recommended and adopted, then they would be misleading and deceiving the union membership. And consequently, the supreme penalty of dismissal is appropriate to be meted on them. Also, the commission of illegal acts in the course of a strike would make it illegal, and the striker involved therein, irrespective of whether he is a union officer or an ordinary member, will suffer the penalty also of dismissal. Under the labor code naman po, even if there is anyway po, the remedy is available always to file for an action for illegal dismissal before the National Labor Relations Commission. And a relief from that action, if found to be illegally dismissed, then the striker will be reinstated without loss of seniority rights, Mr. Chief.
Thank you. So the initial finding of the Department of Labor is you agree with the proposed amendment because there is a provision in the law already on illegal dismissal.
Your Honor, the Supreme Court reasoned that meting the penalty of dismissal is reasonable in cases of knowingly participation in illegal strike and knowingly participation in the commission of illegal acts in a strike.
That is the opinion of Dole, that's why they're called Department of Labor and employment. So, will you agree with me that even the statutory construction, they're always in favor for downtrodden and of course, the magkagawa, the interpreting laws of the labor code. That being said, Mr. Chair, what I'd like to say to Attorney Dole is that the ILO disagrees. In fact, in the high-level tripartite mission in 2009, specifically said that we stated to the yan. So we should preserve employment, however it may be. But then again, we will not turn a blind eye on ano ang ginagawa nila. Instead of dismissal or loss of employment as penalty in this bill, we are proposing that the erring employer employee, employer naman, employee, huwag ka mag-react siya. Would subjected to disciplinary action, be no case shall be an action to loss of his employment status. The rationale is that dismissal or loss of employment is a penalty that is too harsh, that's why it's draconian, and is not commensurate with the violation committed. Again, this is in line with the ILO, International Labour Organization's statement in the high-level tripartite mission way back in 2009, Mr. Chair. And of course, if I may, Mr. Chair, he read the whole statement from Dole, considering also under letter A of Article 264. Mr. Chair, can I just, this, after, it is in line, it's what being said in letter G, where any worker whose employment has been terminated as a consequence of any unlawful lockout shall be entitled to reinstatement with full back wages for the employment. Mere participation of a worker or a union officer in a strike, ito ang palagay namin ilagay dapat, na mere participation of a worker or a union officer in a strike declared illegal for failure of the union to comply with procedural requirements. Again, procedural requirements under paragraph A of this article shall not be a ground for termination of his or her employment, even if the replacement had been hired by the employer during such a legal strike. And it went on, it goes on, any worker or union officer who knowingly participates in the commission of illegal acts during a strike, yun ang concern mo, Panyero, shall be subjected to due process under the jurisdiction of the regular courts over any criminal action, of course, penal code, arising from the violation of any of the provisions of Article 264 of the Labor Code as amended, but subject to the required clearance from DOLE of the Department of Labor and Employment on cases arising out or related to a labor dispute. Mr. Chair.
Mr. Chair? Yes. It seems that I don't have a copy of the amended bill already, because what I have here is the original House Bill 7043 of Congressman Mendoza. But in any case, I would like to, so this is the one. You know, we want order in all the things that we do in our country, especially so in this particular case. Kasi kung alam niya, nakalagay naman dito, any union officer who knowingly participates in an illegal strike, and any worker or union officer who knowingly participates in the commission of illegal acts during a strike may be, nakalagay, under our existing law, may be declared to have lost his employment status. And I assume that when this is provided here, there is due process also here, procedural due process. That before the person is terminated, there will be due process where first it should be established that he knowingly participated in the legal strike and at the same time knowingly participates in the commission of illegal acts. So ito yung maximum penalty actually dito. So kailangan i-prove muna whoever who will file the complaint that there indeed was the commission of an illegal acts of the individual, and the commission is actually parang he knows already that it's an illegal act and yet he still commits the same act. So I think kung lalagay lang natin under pain of immediate disciplinary action, walang-wala, very vague yung disciplinary action. Anong ibig sabihin nun? Hindi maliwanag. So I assume that the existing provision is enough to, anyway, there is due process that will be followed. Procedural and substantive due process are stated in this particular existing provision of Article 264 of the Labor Code, Mr. Chair.
That's why in a sentence of great Congressman Go, taken procedural and substantive. This is where we, well, if you say procedural, for example, no, may problema lang sa NOS, notice of strike, tuloy no period. And of course, the strike vote, ito from dyan. Because of a procedural requirement lang na hindi na-comply, ang dapat trabaho yun. Isang empleyado, hindi naman. But of course, when I stated here that substantive regulations will require also, and it must be ruled in regular, again, in the jurisdiction of regular courts, for criminal action, and then again, that will be under the penal code, but must have respect to the clearance from DOLE on cases arising from such actions, Mr. Chair. I hope Congressman Go will see the light, considering that this has been a subject of much discussion in Geneva, where he regularly attends. It's actually part of the report in the high-level HTML, which is the high-level tripartite mission in, again, in 2009. Mr. Chair.
Thank you, Deputy Speaker. Can we have the opinion of Dole regarding the report of the ILO on the harsh penalty rule being implemented on dismissed employees? Does the comment of ILO, does it hold any value here in our Philippine laws?
Mr. Chair, in 2009, baka si Atty. Wala po kung nandoon na ako, Mr. Chair. By the way, I've been attending ILO since 2000. This is my 24th year, or 22nd year. Mr. Chair, I was there. Congressman Go was not there, so he cannot comment.
Yeah, I was not there, I'm sorry. But, you know, when somebody knowingly participates in an illegal act, and at the same time also knowingly participates in the commission of illegal acts, talagang parang alam niya na bawal yon, illegal yon, at gagawin niya, bibigyan mo lang ng parang pinalo mo lang sa kamay, palagay ko, it might open the Pandora's box. Baka magiging walang bisa itong mga natin, di ba? Yan naman siguro. Ang importante lang dito sa tingin ko, the procedural and substantive requirements are complied before the imposition of the penalty of termination or loss of employment of the individual employee or union officer. Yun ang talagay ko ang pinaka-importante rito. And we want to be sure that effort should be done before imposing the penalty of termination on the part of the management or the employer to the employee or union officer.
Mr. Chair.
Yes.
Thank you, Mr. Chair. Mr. Chair, yung bill kasi is, the proposed bill, yung House Bill 7043, it is seeking to strengthen the workers' right to strike and will fortify our commitment to uphold the workers' constitutional right. Kaya yung removing the clause on harsh retaliatory actions on illegal strike and simplifying the conduct of strike in case of union busting, nagpo-propose po kami dito ng complementary amendments din. Actually, sinulat naman po namin yan kay DS, no? Sa proposal po namin, we would like to clarify the imposition of disciplinary action to exclude termination or loss of employment so as not to defeat the purpose and intent of the measure. Sabi nga, it has been well argued that the loss of workers' livelihood severely affects not just the worker but his or her family as well. Removing it as penalty, however, is not intended to prejudice or discount the company prerogative to impose sanctions nor to condone any unlawful act. So, Mr. Chair, mas leaning on position of PS Mendoza tayo na napaka-harsh naman kung tatanggalan mo kagad ng trabaho yung manggagawa. And specifically, Mr. Chair, narito po si Mr. Joselito Ostares
baka pwede po siya bilang manggagawa, pwede po siyang magsabi kung ano yung nangyayari sa ground, Mr. Chair.
Mr. Chair, ito lang. Kung ang magagawa, tuwan, medyo
Malabo sa-
tanggal. Yung penalty, no, that's why it imposes pagtanggal termination sa trabaho. But what if yung kapitalista, yung management, and they sometimes knowingly violate, and they always do that. Bayad lang sila 10,000 to 100,000 pesos. Kami, tanggal sa trabaho. Sila, patuloy. Kala lang yung 10,000, 100,000. Sabihin na lang yan sa corporate funds. Diba? So, that's why I am saying that it is actually swayed against. So that is why level na rin playing field. Again, fully noted na substantive substantive in violation should be dealt with accordingly and we have been on course with that. Thank you, Mr. Chair.
Thank you, Deputy Speaker. Can we hear from Mr. Lito Ustanes, KMU, regarding the perspective of the manggagawa on the harsh penalty?
Magandang umaga po, Mr. Chairs. Maraming salamat at nabigyan ng pagkakataon ng mga manggagawa na lumahok dito sa discussion. Masarap pong pakinggan yung title na Strengthening the Workers' Right to Strike. Sarap pakinggan. Parang napakalaya ng mga manggagawa para magwelga, para mag-strike. Pero sa totoo lang po sa ground, marami pong exit na nagiging sagabal doon sa mga aksyon ng mga manggagawa sa grounds. Una-una po, meron pong dalawang nagpapahirap din sa mga manggagawa. Tama yun, yung binanggit na kanila na dapat yung mga manggagawa ay hindi basta-basta tinatanggal. Pero sa grounds po, ang nangyayari, meron pong dalawang klase ng pagpapail ng strike. Halimbawa sa CBA deadlock, pwede pong mag-file ng strike ng manggagawa. Ganun din po sa ULP, pagka merong ULP ginawa. Kaya lang po, yung tagal, doon sa tagal ng time na merong cooling off period, halimbawa CBA deadlock, merong cooling off period na 30 days, wherein sa ULP o unfair labor practice ay merong 15 days na cooling off period. Dito po sa mga panahon ito ay nangyayari yung mga attacks ng management sa union, sa mga manggagawa. Kung minsan po, hindi pa nakapagpapile ng notice of strike yung mga manggagawa, tinatanggal na. So, tinatanggal na sa kumpanya. Karamihan pong tinatapahan dito yung mga opisyalis ng union halimbawa, kapag ka nag-file ng NOS, yung isang union, meron pong 30 days na cooling off period. Nagpapatawag ang NCMB niya ng conciliation, natatatawag yung management and union, and then during the conciliation, mas madalas pong nangyayari na nagiging karanasan namin, sa unang-unang conciliation meeting pa lang, ay nagpapail na yung management ng assumption of jurisdiction. So kasabay po nun, unang-unang hearing pa lang na ipinatawag ng management ng DOLE, ng NCMB. Meron na siyang ipinapail. Ang management ay nagpapail na ng assumption of jurisdiction. Kasabay po nun yung pagpapail din niya ng lockout sa kumpanya. So, ano po yung gagawin ng mga manggagawa sa panahon yan? Wala siyang D-way, wala siyang pwedeng ikutan. So, ano yung gagawin niya? Maggagawa po siya ng mga mass action o sama-samang pagkilos, magkakaroon ng mga general membership assembly, magkakaroon ng mga meeting yung mga manggagawa. Pero sa panahon yan, dahil sabi nga natin ay merong merong cooling off period, hindi niya magawa yung karapatan niya na dapat sana ay magawa niya sa panahon yan. Kaya pagka nag-file na ng assumption of jurisdiction, yung management, nandiyan na agad yung mga restriction. Hindi ka na pwedeng gumawa ng mga aksyon, ng mga sama-samang pagkilos, hindi ka na pwedeng gumawa. Dahil ang gagawin niya, yung management yan, magpapile na siya ng illegal concerted action. Yun na yung magiging kasunod. At sa karanasan po namin, meron pong decision ng ang Supreme Court sa illegal concerted action na ang sabi niya ay illegal yung strike. So, saan pa pupunta yung mga manggagawa? So, napakahaba po, dito sa panahong ito, napakahaba ng proseso. Gusto ko lang po i-cite yung, siguro pinakahuli. Isa-cite ko lang po yung nangyari sa Hacienda Luisita. Meron din po yung, pagkamat iba yung forum sigurong pag-usapan yung assumption of jurisdiction, pero yan po yung ginamit ng management to sa Hacienda Luisita. Tapos sa meron naman rin siyam, maraming sugatan, no? At talagang yung strike mismo, dineclare na illegal. So, saan pupunta yung mga manggagawa? Nasaan yung kanyang binabanggit nating right to strike, yung karapatan ng mga manggagawang magwelga. Kaya sa amin po, napakahirap. Yung illegal, yung ULP, pagka sinabing ULP, lahat ng specialist tanggal. So, may mga kaso na yan. Ano gagawin ng mga manggagawa? Kung tinanggal na yung mga specialist, hindi magwewelga. Talagang ganun yung direksyon eh. Yan talaga yung magiging isip na ng magiging nasa kumbaga instinct ng mga manggagawa na ipagtanggol yung kanilang karapatan sa pamamagitan ng sama-samang pagkilos o welga. Kaya yun po, yung isang napakahirap na sitwasyon, napakahirap na kondisyon sa mga manggagawa sa grounds.
Salamat po. Salamat. Can we also hear from the management, ECO, represented by Mr. Robert Maronilla?
Good morning, Mr. Chairman. Good morning po sa lahat ng members ng committee. Good morning po sa lahat. Thank you, Mr. Chairman. First of all, I would like to manifest, we will be submitting a position paper because I just read the amended version today. And Mr. Chairman, reading the explanatory note of Honorable Mendoza, the high-level mission is mentioned here. I would like to note lang po that Convention 87, which talks about the freedom of association, does not contain any provision whose ordinary or literal meaning would imply the existence of a right to strike. Matagal na pong pinag-debate ito ng employers at ng labor, meaning po, for the employers group worldwide, the right to strike is not included under Convention 87. For the workers group po worldwide po, the right to strike is included under Convention 87. So I would just like to note that dun po sa according to the ILO, wala pa silang final decision on this. So based on the employer side, the right to strike is not included under Convention 87, which is the right to organize. Second po, Mr. Chair, yung sinasabi po natin na too harsh of a penalty, no? If we think of things in a general sense, I think the purpose of the law, that's why po too harsh ito ay because the entire business is at risk. Kapag nag-strike po, yung buong kumpanya po is affected, no? Not just management but also labor. So yun lang po ang purpose niya. I fully support the position of Honorable Go that there are safeguards already in place. Existing laws already are there, and as long as procedural and substantial due process is followed, I don't think there will be a problem with that. Yeah, in summary po, Mr. Chairman, I would just like to share with you the position of the Employers Confederation of the Philippines, that we are not inclined to support the bill in its entirety. Kindly wait for a position paper because there are new amendments na po. Yun lang po. Thank you.
Thank you very much.
Mr. Chair, is it possible for PUCP, our spokesperson is here? Thank you.
Yes. Can we hear from Mr. Louis Corral?
Thank you, Honorable Chair. Two things. With respect to the right to strike, which is a constitutional right, and with respect to cooling off period. With respect to the right to strike, you cannot implement fully the spirit and intent of ILO Conventions 87 and 98. The right to organize and the right to collectively bargain without the economic right of workers to peaceably express grievances, including the right to strike. And that is constitutionally protected. On the matter of assumption of jurisdiction, that forms a package of reform measures that the high-level tripartite mission has recommended for the Philippines, and which the UCP has discussed with both the Speaker of the House and the Majority Floor Leader, with the Deputy Speaker. And there is this sense that we have to move away from the aversion of the last 6 years from human rights and labor rights simply because previous thinking of the powers that be, where these were Western-oriented. We have common values. We have common ideas of what is right and wrong. And that's where this proceeds from. On the matter of the cooling off period, we do have fundamental difference from the position of KMU. The position of the UCP is the cooling off period should apply to collective bargaining disagreements and deadlocks and unfair labor practices. It is only in instances where the unfair labor practice constitutes union busting where the cooling off period should not apply. Yung tatanggalin yung mga opisyal ng union o talagang widespread at flagrant yung violation ng labor rights. So, the cooling off period is now fundamental because of the nature of our labor market and employment market. We don't have large manufacturing firms anymore because of the power costs. We have essentially a service sector. And the service sector employer would just laugh at us and say, okay, let's make it easier for strikes to happen. So, hayaan natin sila mag-picket dun sa labas, lilipat lang tayo. That's the reality. So it is very needed at this point of time, where labor density is now down to 5%, for the Department of Labor and Employment to step up and intervene through mediation and conciliation to save not just the business, but more importantly, to save jobs. That is the harsh reality of our labor market. So the right to strike, while fundamental and uncontestable, should be exercised within parameters that provide for decent work. So the package of amendments, Your Honors, that have been proposed to the Speaker, including limiting assumption of jurisdiction only to matters that refer to essential industries as listed down by the International Labor Organization, and not national interest, which is too broad and too wide in its application, such that even a match factory or a factory producing slippers or underwear could be placed under ambit of national interest. So what we are really doing is revising our labor code to conform with both the needs to balance the interests of labor and the interests of management at a time when labor strength is at a decline, when widespread contractualization makes it impossible for workers to organize because of corporate impunity and fear of the bosses, when there is also the presence, unsaid, unspoken, of state impunity. That's why even the NPFL is trying to camouflage and organize itself by calling itself the National Task Force for National Unity, Peace and Development. So, that is the context. Now, having said that, what is the international trade implication and employment market implication? Well, both the U.S. government, we were fortunate enough with the Deputy Speaker to meet with the National Security Advisor of the U.S. last December, and the U.S. Trade Ambassador, Catherine Tai. So we met with Jake Sullivan and Catherine Tai, and under their current U.S. global labor policy, there is this worker-centered focus on trade. And that is the reason for negotiations on the Indo-Pacific Economic Framework right now. That is the consideration for the possible reauthorization by the U.S. Congress of the U.S. GSP. That is the reason, incidentally, for the extension by 2 years of the EU GSP. That translates to 6,500 product lines, which now can enter the United States and Europe tariff-free. That translates, of course, to hundreds of thousands of possible decent unionizable jobs. Having said that, there's one last point. Last Friday, the Deputy Speaker and I met with Alice Albright of the Millennium Challenge Corporation. They skipped the last 6 years because they said, well, we don't see human rights. Now they're back in business with the Philippines. They're looking at a small grant component of $30 million, a threshold grant. But beyond that, they're looking at an $800 million grant, a compact grant, similar to what they gave in 2014 for Calafi Seeds, for building roads in late summer. So the pivot of President Marcos to a worker-centered trade regime, I think is what we should take a look at, because it is now consistent with international trade practices, outside, of course, of the model of China. So with that, Your Honors, we hope that this bill, with the recommendations of the Deputy Speaker, will be adopted by the committee.
Thank you very much, Mr. Louis Vera. Can we hear from NCMP?
Thank you very much, Honorable Chairperson and the Deputy Speaker and sponsor of the bill. The NCMP at the outset would like to reiterate our support for the workers' constitutional right to participate in the right to participate in self-organization and peaceful concerted action. So support po kami po. With regard to the removal po ng penalty of dismissal or loss of employment status as a penalty for violation of orders, prohibitions, or injunctions issued by the Secretary of Labor, we would like to propose that it be revisited. We acknowledge po na yung current provision is placed in the labor code to caution our union officers and members to only employ means that are lawful to attain their legitimate objectives. So, kagaya po ng sinabi ni Honorable Go, na yung mga systems natin are in place naman po to ensure na yung mapaparusahan lang talaga ng dismissal ay yung nag-commit ng crimes. Yung mere participation, hindi naman po. So, tinitignan po naman ng pagkakataon yung mga ganong kalabisan. So, yun lang po talagang nagmalabis. Yun lang po siguro ang dapat maparusahan ng penalty of dismissal and loss of employment status. Regarding naman po doon sa cooling off period, we agree with Sir Louis Goral na dapat i-preserve po yung cooling off period dahil yun po yung pagkakataon ng NCMB na mag-usap at maghanap ng solusyon para sa saan man pong disputes. So, kung aalisin po yun, ay magkikipit tayo sa paghahanap ng paraan para po ma-resolve ang isang issue or dispute. So, balit, pagka nagkaroon naman po ng union busting, kagaya po ng nangyayari ngayon, ay dinidispense naman po yung cooling off period at yung strike ban period lamang po ang in-observe. So, both po yun sa interest ng buong public, ng buong clients po natin ang sineservisyohan. Dahil alam po natin na ang pagkakaroon ng strike would be detrimental not only to the employees involved but also to the business na alam naman po natin dapat na magpatuloy to have the Philippines in a place for investment and business.
Thank you very much. We would like to recognize Representative Romeo Acop, Second District, before the city. Can we hear from NAPSI, Mr. Edwin Bustillos?
Thank you, Mr. Chair. I'm Edwin Bustillos from the National Anti-Poverty Commission, Formal Labor and Migrant Workers. Let me get straight to the point, Mr. Chair. First, we would like to manifest that a strike is not a criminal act. That's the first point. Henceforth, we would like to support House Bill 7043 in its entirety. But let me testify, Mr. Chair, regarding the section where instead of a termination, the penalty should be lower, probably disciplinary action like suspension. To recall, Mr. Chair, please, I would like to stress that in GR 165576, it's a Supreme Court ruling of the Third Division under Justice Natura. The Supreme Court justices mentioned that termination is too harsh a penalty. In fact, I was the union president of Samahan ng mga Manggagawa sa Hayat at the time. We conducted a strike. They said that our strike is illegal, but upon the wisdom of the Supreme Court justices mentioned that 6 months suspension is too harsh a penalty. They even reduce it, Mr. Chair, ng 2 months. No, it's in the record. So, hindi po pwede na i-terminate po kagad yung mga officers na in good faith nag-conduct ng strike because of union busting or other ULP acts committed by the employer, no? Second po, klaro din po dun sa desisyon ng Supreme Court na yung pong mga grounds for strike like CBA deadlock, particularly economic provision, massive violation ng economic provision, and ULP ay ano naman po, no? Nasa intention naman po ng trade unions to survive. Kaya po yung kanilang act to go on strike ay protected din naman po as mentioned by Deputy Speaker Mendoza. And lastly po, we will also support the cooling off period as mentioned by TUCP. I think with due respect, the National Conciliation Mediation Board is doing their best naman in conducting preliminary hearings and conciliation mediations, particularly on CBA deadlocks and even ULP. But of course, if there is union busting, definitely the cooling off period should be waived kasi napaka-imposible po na tinanggal na yung mga union officers like what we have in Hayat, Regency Manila at that time, tinanggal na, dada pa kami ng cooling off period. So I think, Mr. Chair, yung pong proposal is in order. There is a basis decided by the Supreme Court na ang penalty po can be reduced actually ng 2 months lamang.